right, go. We're recording.
380.10. At any time during the trial, the court must declare a mistrial and order a new trial of the indictment under the following circumstances.
Okay, I think, can I try to name them?
Sure, go right ahead.
Okay. It is physically impossible to proceed with trial in conformity with law. Or, wait a minute. Defendant does something so egregious that, you know what, just tell me.
Okay, so this question actually has three parts. It's by motion of the defendant, or motion of the people, or motion of either party or the court's own motion. So I'm going to read by motion of defendant first.
Okay.
Okay, so by motion of defendant first, the court must declare a mistrial and order a new trial of the indictment under the following circumstances when the motion is by the defendant. When it occurs during the trial, an error or legal defect in the proceeding, conduct inside or outside the courtroom which would be prejudicial to the defendant and deprives him of a fair trial, and when it is physically impossible to proceed with the trial in conformity with the law. Now, if it's motion of the people, it's only gross misconduct by the defendant or someone acting on his behalf or a juror resulting in substantial irreparable prejudice to the people's case inside or outside the courtroom, and when it physically is impossible to proceed with the conformities of law. Now, if it's motion of either party or the court's own motion, if it's a court's own motion, it's only when it is physically impossible to proceed with the conformity of the law.
Okay.
Okay, you want me to read them one more time quick?
Yeah, sure.
Okay. So, a motion for a mistrial, if it's made by the defendant, there has to be an error or legal defect or conduct inside or outside the courtroom which is prejudicial to him, or when it is physically impossible to proceed with the trial in conformity with the law. If the motion is by the people to declare a mistrial, it's only when there was it's two things: when it's gross misconduct by the defendant or someone acting on his behalf or a juror resulting in irreparable prejudice to the people's case, or when it is physically impossible to proceed with the trial in conformity with the law. And if it's motion of the court, it's only when it is impossible to proceed with the trial in conformity with the law.
Oh, I thought there was something about all three of them agreeing, but anyway, I guess I mixed that up with something else.
Yeah, it just has to do with errors and legal defects and misconduct and physical impossible to proceed in conformity to law. So that's basically it in a nutshell. It has to do with somebody doing something that's going to prejudice someone's case.
Yep.
Or errors or defects if it's the defendant. All right?
Okay.
All right. Next, when blank, blank, or blank during a trial, a joint trial, or two or more defendants, and a mistrial motion is made by one or not more, but not all, the court must declare a mistrial only as the defendant or defendants making the motion. The trial of the other defendants must proceed.
That's true.
Error, defect, or conduct.
Yeah, it's true. They have to go forward.
Right. Last question as well. This is the last question. This was a short one. True or false? When there occurs gross misconduct by the defendant, other person, or juror resulting in substantial irreparable prejudice to the people's case, when such misconduct occurs during a joint trial of two or more defendants, and when the court is satisfied that it did not result in substantial prejudice to the people's case against a particular defendant, that such defendant was in no way responsible for the misconduct, it must declare a mistrial with respect to such defendant, but proceed the trial to the other guy.
Yeah, and that's an and, right? It has to be both.
Yeah, it says
it's that it didn't result in prejudice and he wasn't responsible. Is it an and?
Prejudice when the misconduct occurs in the joint trial, two or more, and when the court is satisfied that it did not result in substantial prejudice.
Okay.
Yes, and okay, 290. 290.10. At the conclusion of the people's case, or at the conclusion of all the evidence, the court may, upon motion of defendant, issue a what?
A trial,
dismissing
a
any
TOD.
count, dismissing any counts of the indictment.
Trial
A
order
trial
dismissal.
Correct. Upon the grounds that the trial evidence is not legally sufficient to establish the offenses charged or any lesser included offense, or the court may, upon motion of defendant, reserve decision on his motion after the verdict has been rendered and accepted by the court. So he can make a trial motion for dismissal, but if the jury is deliberating, they can wait, right?
Yeah.
But the jury does, because the jury might dismiss it anyway.
Yeah, the jury might say not guilty, so then the judge doesn't have to decide it.
Right. Where the court has reserved the decision and the jury thereafter renders a verdict of guilty, the court shall proceed to determine that motion. If the court determines that motion should not have been granted, that motion should have been granted, upon the grounds that the trial evidence is not legally sufficient to establish the offenses charged, it shall enter both and order both what of the indictment upon the grounds, setting aside the verdict and dismissing any count
Okay.
of the indictment. If the jury is discharged before rendition of the verdict, the court shall proceed to determine the motion. 3. Despite the lack of illegal insufficient trial evidence of an indictment, issuance of a trial order of dismissal is not authorized and constitutes error when the trial evidence would have been legally sufficient had the court not erroneously excluded admissible evidence offered by the people. True or false?
That's true. Then the
Why
people.
would they? I don't understand. Why would the court erroneously exclude it?
Well, they're saying that if the court excluded evidence and then the appellate court decided that it was erroneous, then they would remit.
Okay.
Yeah.
Okay. When the court excludes trial evidence offered by the people, under such circumstances that the substance or content does not appear in the record, the people may, in anticipation of possible subsequent trial order of dismissal emanating from the allegedly improper exclusion or erroneously issued in violation and in anticipation of a possible appeal, the people may place upon the record, out of the presence of the jury, a what?
Offer of proof.
Offer of proof. Summarizing the substance and content of the excluded evidence. Upon the subsequent issuance of a trial order of dismissal and an appeal, such offer of proof constitutes the record on appeal. In the absence of a trial order of dismissal and an appeal, the offer of proof is not deemed to be part of the record and does not constitute a purpose for ensuring appeal by defendant from a judgment or a judgment of conviction. Last one. True or false? Upon issuing a trial order of dismissal, which dismisses the entire indictment, the court must immediately discharge the defendant from custody if he is in custody. If he is at bail, on bail, it must exonerate the bail.
Yep.
Okay. 300. At the conclusion of the summations, the court must do what?
Deliver a charge to the jury.
Correct. 310. In its charge, the court must state the fundamental legal principles applicable to criminal cases in general. Such principles include, but are not limited to, the presumption of the defendant's
Innocence.
the requirement that guilt is proven.
Beyond a reasonable doubt.
The jury may not, be in determining guilt or innocence, consider or speculate matters relating to
Sentence or punishment.
Exactly. Upon request of the defendant who did not testify in his own behalf, but not otherwise, the court must state that the fact that he did not testify in his fact is not a factor from which any inference unfavorable to the defendant may be drawn. True or false?
Oh, that's true.
4. Where a defendant has raised the affirmative defense of lack of criminally responsible by reason of mental disease or defect, the court must, without elaboration, instruct the jury as follows. Quote, a jury A jury during its deliberation must never consider or speculate matters relating to consequences of the verdict, not responsible by reason of mental disease or defect. I charge you that if that is your verdict, if that verdict is rendered by you, there will be a hearing as to determine the defendant's present mental condition and, where appropriate, involuntary commitment proceedings. True or false?
That's true, and I know that I think I would recognize that exact language if I saw it on the test.
I would recognize it too.
Good.
Okay. 2 or more counts of an indictment upon which consecutive sentences may impose are called?
Consecutive counts.
Correct. 2 or more counts of an indictment.
Let me try to give you the definition for this one. Okay, because I just did it last night.
Okay.
Concurrent counts are counts where concurrent sentences only may be imposed.
Right.
Okay.
And concurrent counts are when the offense charged is okay. I'm sorry. What is the definition of this? This makes me laugh all the time. This sentence. I remember Mike saying this in his class, actually, not like 12 years ago. Mike Baganska saying this, and I laughed so hard.
Oh wait, is this that one like inclusive?
This is the one that I said you should show your husband.
Inclusive.
Yes.
Yeah.
Yes.
And ask him what the fuck that means. The test isn't hard.
This is what you should tell your husband you've been reading all day. Concurrent counts are inconclusory when the offense charged is one is greater than any of those charged in the other, and when the latter are all lesser offenses included within the greater.
Oh my god, how does anyone even know what that says?
Who cares? All other kinds of concurrent counts are inconclusory or not conclusory. When guilt of the offense charge of one necessarily negates the offense charges in the other, what are they called?
Inconsistent counts.
Correct. I have a star next to this one. The courts may submit to the jury only those counts of the indictment remaining at the time of the charge which are supported by legally sufficient trial evidence, and every count not so supported should be dismissed by
A trial order dismissal.
and the court's determination as to which of the sufficient counts ought to be submitted must be in accordance with the following rules. 1. If the indictment contains only one count, the court must submit.
Such count.
Multiple count indictment contains consecutive counts only. The court must submit.
Each of them.
If a multiple count indictment contains concurrent counts of murder in the first degree, the court must submit.
Oh, if it contains concurrent.
Every count.
Okay.
Because if it's murder, it's every count, even if it's concurrent.
Can you say that again, like in a sentence?
Let me just finish this last sentence,
All
and I'll
right.
say it again. And if it's not murder and it's concurrent, then it's at least one of them.
Okay.
At least one count. Okay, so I'll read them again. You ready?
Yeah.
The court's determination as to which of the sufficient counts ought to be submitted must be in accordance with the following rules. If the indictment contains only one count, the court must submit one count, such count. If a multiple count indictment contains consecutive counts, the court must submit every count. If the multiple count indictment contains concurrent counts of murder in the first degree, the court must submit every count. If it's concurrent counts but not murder, it says in all other cases, if multiple count indictment contains concurrent counts only, the court must submit at least one of the counts. Okay, so concurrent, you only have to do one unless it's murder.
Okay.
Consecutive, you got to submit every count.
And that's murder first?
Murder one.
Okay.
Every count not submitted to the jury is deemed to have been
Dismissed by trial order dismissal.
just dismissed.
Oh,
says.
okay.
All right, we're done with 300.
Wow.
Yo, we're whipping through these, girl.
Oh, wait, I got a question for you on 300 because I didn't hear you say it.
Sure, I'm going to go get some candy. So go
Oh,
ahead.
okay. All right, so my question is, the court must specifically designate and submit in accordance with the provisions of Section 300 and 330 and 340, those counts and offenses contained and charged in the indictment which the jury are to consider. Such determination must be made and the parties informed thereof when.
Can you read it one more time?
Yeah. The court must designate and submit to the jury the counts and offenses contained and charged in the indictment which the jury are to consider. Such determination made and the parties informed thereof when.
I'm gonna say after summation.
Prior to summations.
It's prior to summation.
Yeah.
So read it to me with that in it sentence.
Okay. So the court must designate and submit specifically the counts and offenses contained and charged in the indictment which the jury are to consider. Such determination must be made and the parties informed thereof prior to summations.
So
And then-
they have to tell the judge. They have to tell the jury which counts they're going to be considering before the people.
No, they have to tell the lawyers.
Oh, they have to tell the lawyers which counts they're going to be submitting before the lawyers give their closing argument.
Yeah, the court has to say what count it's going to submit to the jury before the lawyers sum up.
Okay.
So that the lawyers don't waste the jury's time telling them about stuff that isn't even going to be
That's not
submitted.
going to be considered.
Yeah. Okay, so
Right.
now I have one more question.
Go ahead, because I'm almost done.
The jury must render a verdict of what on each count? And there's only 3 options.
Okay.
What can they
Oh,
say?
Oh, you mean guilty, not guilty, or something else?
Yeah.
Guilty is one.
Yep.
Not guilty.
Yep.
Not guilty by reason of mental disease or defect.
Perfect. That's it.
Is that it? I just guessed.
Yep.
Holy shit! So those are the 3 outcomes.
Yep. Okay, now here we go. When may the parties submit requests to charge?
At any time. Anytime.
It's before and after the court's charge. So yeah. And can they be orally or in writing or both?
I say both.
Both. Yep. And the court must
So
rule.
in other words, the jury can ask for instructions at any time from the court, right?
This says the lawyers can request charges.
Oh.
And then
I was thinking of something else. I think I was asking for when the jury wants instructions from the court.
okay, and then the court must rule blank on each request. I'm looking for a time period.
Promptly.
Yep. A failure to rule on a request is deemed.
I know. It is deemed dismissed or something else.
Denial. It's a denial.
I think of the word.
All right, that's it. That's all I got.
All right. I remember those though.
Yeah, that's good.
All right.
I'm sorry, I have one more question.
Okay.
So I'm looking for an age here where the indictment charges a crime committed by a defendant while he was under the age of blank, but a lesser included offense would be one he is not criminally responsible for. Such lesser included offense may nevertheless be submitted to the jury in the same manner.
I don't understand the question. What are you looking for?
I'm looking for the age. How old?
All right. Say it one more time and then I'll get it.
Okay, where indictment charges a crime committed by defendant while he was under the age of blank, but a
Okay.
lesser included offense would be one for which defendant is not criminally responsible for. Such lesser included offense may nevertheless be submitted to the jury.
I'm going to say under the age of 17.
It says 16.
Fuck. Because I'm thinking adolescent offender.
Me
is-
too. But I guess that's only, because, I don't know, that's what it says.
Fuck. Wouldn't you think 17?
Yeah, I would have too, but it says 16.
So read it to me with the age now, just so I
Okay.
can get it in my brain.
All right. Where the indictment charges a crime committed by defendant while he was under the age of 16, but a lesser
0 to 15.
but a
Okay.
lesser included offense would be one for which defendant is not criminally responsible for by reason of infancy. Such lesser offense may nevertheless be submitted to the jury,
Okay. Under the age of 16.
notwithstanding that it would not result in a criminal conviction.
We have to remember that.
I know.
Okay, following the court's, this is 310. Following the court's charge, the jury must what outside of the courtroom?
Deliberate.
retire to deliberate. They must be continuously kept together under the supervision of a court officer or public servant, except when authorized by the court. Such officer or public servant may not speak or communicate with them or permit them to do so. 2. At any time after the jury has been charged or commenced its deliberations, and after a notice to the parties and affording each party an opportunity to be heard, on the record outside of the presence of the jury, the court may declare the deliberations to be in recess and may direct jury to suspend its deliberations and separate for a reasonable period of time to be not exceed how long?
Oh, I don't remember.
Oh, I think or 24 hours?
Is it 72 hours? I don't know.
24 hours.
All right, can you read it with the answer in it?
Yes, and then there's another 24-hour rule in it. It's just one more sentence. Let me read that. Before each recess, the court must admonish the jury and direct it not to resume its deliberations until... Oh, I'm sorry, I skipped a spot. Except that in the case of Saturday, Sunday, or holidays, separation may extend beyond 24 hours. And then before each recess, the court must admonish the jury and direct them not to resume its deliberations until all 12 jurors are reassembled. Okay, I'll read it again. At any time after the jury has been charged or commenced its deliberations, and after notice to the parties and affording each party an opportunity to be heard on the record but not in the presence of the jury, out of the presence of the jury, the court may declare that the deliberations go to recess, be in recess, and may direct that the jury suspend the deliberations and may let them separate for a reasonable period of time, and the reasonable period of time is not to exceed 24 hours. It's a Saturday, Sunday, or a holiday, the separation may extend beyond the 24 hours.
Okay.
And when they come back together to re-deliberate again, the judge told them, don't start talking until everybody's back together.
Got it.
No, to all 12 people are back, don't start, your bullshit.
Yeah.
All right, 3:10:20. Upon retiring to deliberate, the jurors may take with them any blank received at trial.
Okay, it's any exhibits.
It says evidence, but that's fine.
Oh,
yeah.
Evidence. Why do I keep saying? Okay, so any
After,
evidence.
according to the parties, an opportunity to be heard upon the matter, the court permits them to take. So the court will give them an opportunity to be heard, and if the court permits them to take them, then they can take the evidence.
All right, so I just did this last night, and it's for the evidence, for the exhibits or whatever, the evidence, it's just opportunity to be heard. But a copy of a statute, it has to be consent.
Okay. Well, yeah, I think I'm getting to that.
All right.
I think you're right. Yeah, it's right here, consent. It's in the next question. And then it goes on to say a written list is prepared by who? Of the witnesses and containing the offenses
by the court.
Right.
I knew they were about a fucking witness list. Okay.
Okay, so let me read it again. 3:10:20 says, upon retiring to deliberate, the jurors may take with them any evidence received at the trial after according the parties an opportunity to be heard and the court permits them to take. Also, a written list prepared by the court containing the offenses submitted to the jury, and also a written list prepared by the court containing the names of every witness who testified during the trial. But if the jury requests such lists and the court in its discretion determines the list will assist the jury. It's only if the jury requests it.
The jury requests it and the court determines it will assist
and
the jury.
Court, right, determines it's going to assist them. So that list of witnesses isn't only if the jury requests it.
And that one doesn't require consent or opportunity to be heard.
And neither does the list of the offenses.
All right, so it's only the exhibits, opportunity to be heard, the witness list, and the list of offenses is if they request it, and nothing about the parties. And then the other one, the copy of statute, is the consent.
They may take evidence if they have an opportunity to be heard and the court lets them. The written list of the offenses is prepared by the court, and the written list of the witness is prepared by the court, but only if they request it and the court determines that it's going to assist them. Then it says in 3:10:30, that at any time during the deliberations, the jury may request the court for further instructions or information with request to the law. And when they request to the law, it says, with respect to content, substance of evidence, and other, this is what they're requesting. They're requesting instructions on information with request to content, substance of evidence, or other matters pertinent to the jury's consideration of the case. And upon such request, the court must direct the jury be returned to the courtroom, and after a notice to both people and counsel to the defendant, and in the presence of the, I'm sure it's respondent, of the defendant, in the presence of the defendant, must give such requested information instructions as deems proper. But upon request for instructions with respect to statute, then, and consent of,
Both parties.
what question is this for? The parties, right. The court must also give the jury copies of any text of any statute it deems proper. So if they're asking for instructions on law with respects to content, substance of evidence, matters pertinent to jury's consideration, they don't need consent. But if they give statutes, then they need consent.
Got it. Okay.
Okay? Law, no consent. Statutes, consent.
Oh
But
my God.
They say, but if they do it for law,
Because I think the law instructions they're talking about, it's oral, and the copy
Right.
of the statute is like something they take back with them.
but if it's the law one, the statute, they have to get consent. But if it's the law one, they have to give notice to both people and counsel for the defendant, and do it in the presence of the defendant.
Right, but that's why it's oral. The other one is talking about
Right,
giving them a
right.
copy
And
of
they
the
have
written.
to give notice.
Yeah, they. So that one's the notice, and then do it. Yeah, because one's definitely the oral thing.
31040, the verdict must be rendered and announced by who in the courtroom?
The four-person.
Correct. And in the presence of who, and who?
Okay, so it's the defendant, the court, any prosecutor, and is that it?
The defendant's counsel.
Oh, and okay, yeah, defense counsel.
And where the blank refuses or is unable to render and announce the verdict, the court must designate another member to do so. Four-person.
Yeah. Oh, that's
And
weird.
why would they refuse to render the verdict?
I don't know. Maybe they got a sore throat or something.
Maybe they're just shy. I don't know.
Maybe. It's weird.
All right. Before rendering and announcing the verdict, this is a true or false. The four-person and other members of the jury designated by the court must be asked whether the jury has agreed upon a verdict and must answer in the affirmative.
True.
Go ahead.
A deliberating jury may be discharged by the court without having rendered a verdict when there's 3 times.
All right. So when is this the one where everybody agrees?
Yes, I think
Okay,
so.
everybody agrees, or the jury has been deliberating for an extensive period of time,
Yes.
and the court, in its opinion, decides that there's no way these people are ever going to agree. Like,
Right.
it's unlikely within a reasonable time or something, or
No.
everyone agrees, or a mistrial is declared.
Yeah, you got it. You want me to just read them real quick?
Yes.
So a deliberating jury may be discharged by the court without having rendered a verdict only when the jury has deliberated for an extensive period of time without agreeing upon a verdict, and it is satisfied that any such agreement is unlikely within a reasonable time. And 2, the court, the defendant, and the people all consent to the discharge. And 3, a mistrial is declared. When the jury is so discharged, the defendant may be retried upon the indictment. Upon retrial, the indictment is deemed to contain all the counts which it contained, except for those which were
Acquittal or deemed an acquittal.
right, unless they were dismissed or acquitted.
Oh shit! I got that wrong then.
Yeah. Except for those that were dismissed or were deemed to have resulted in an acquittal.
So those were okay. So it's dismissed or
Acquittal.
acquittal. All right.
So I'll read again. When the jury is so discharged, the defendant may be retried upon the indictment, and upon retrial, the indictment is deemed to contain all the counts that it contained from the very beginning, except for the ones that were dismissed or were deemed to have resulted in an acquittal.
All right, so dismissed or deemed to have resulted in an acquittal.
Right.
All right.
If a deliberating jury declares that it has reached a verdict with respect to one or more, but not all of the offenses, or one or more, but not all of the defendants, the court must proceed as follows. A, if the possibility of ultimate agreement to the other offenses or defendants is so small, or the only matters under consideration, that the court would be authorized to discharge the jury, the court must blank the deliberations.
It must terminate the deliberations.
Correct.
Okay.
And order the jury to render a what with respect to the offenses and the ones that they already reached a verdict on?
Partial verdict.
Perfect. Or the other scenario is B. If there is a reasonable possibility of ultimate agreement to unresolved offenses, if the court thinks that the jury can possibly come to an agreement, the court may either, one, order the jury to render a verdict upon the offenses it has reached already and resume its deliberations upon the remainder, or refuse to accept the partial verdict and order the jury to resume upon the entire case.
Okay.
Right? So if they come back and they only have part of it, the judge can take a partial verdict and tell them to go finish the rest of them, or not take any of them and tell them to go fix the rest of them.
Right. Okay.
All right, did that make sense?
Yeah, I have a question for you now.
Sure. 31070. If a deliberating jury declares that it has reached a verdict with respect to one or more but not all of the offenses, or with respect to one or more but not all of the defendants, the court must proceed as follows. It can, if the possibility of ultimate agreement to the other defendants or offenses is so small, or there's only matters under consideration, the court would be authorized to discharge the jury pursuant to 31060, and the court must. I forgot the answer. The court must terminate the deliberation and order the jury to render a partial verdict with respect to those offenses or defendants upon which it has reached the verdict. But if there is a reasonable possibility of ultimate agreement to unresolved offenses, the court may either order the jury to render a verdict upon the offenses it has reached agreement on and resume its deliberations upon the rest of them, or refuse to accept the partial verdict and order the jury to resume its deliberations upon the entire case. But the defendant is not criminally responsible by reason of infancy. The court shall proceed as follows. If a verdict of guilty for the crime which the defendant is criminally responsible for, or is awaiting sentence upon another criminal conviction, or is under a sentence of imprisonment on another criminal conviction, the verdict rendered with respect to the crime for which he is not criminally responsible for must be set aside and shall be deemed, don't tell me, let me think, shall be deemed...
I don't know either. I don't know any of this one. I want you to read the whole thing.
Yes, you do, because I remember doing this with you.
I know. I do know it, but I won't tell you.
It's vacated.
Yeah, but this isn't the one.
No, it's a nullity.
This is the one. This is the one I always fuck up. The one I remember is the next one.
And one's vacated.
No, one is vacated and deemed by a juvenile delinquency fact determination, and the other one.
I'm getting to you.
All right, but the one I forget is the nullity. So can you go back and read that again?
Okay, the one that's a nullity is the first one.
What is it?
It says where the verdict of guilty is rendered, but the defendant is not criminally responsible by infancy, the court shall proceed as follows. If the verdict is guilty for the crime which the defendant is criminally responsible, so they say it is guilty, he is criminally responsible, or he's waiting a sentence for another criminal conviction, or he's under sentence for another criminal conviction, the verdict rendered with respect to the crime for which he is not criminally responsible. I don't understand that.
All right, so I'll explain this to you.
Shall be set aside and shall be deemed vacated.
All right.
First they said he is criminally responsible, then he said he's not criminally responsible.
All right, so okay, so I'm gonna look at this one because I always fuck this one up.
You want me to send you a photo of it?
No, I'm looking at it in the statute right now.
Okay.
All right, so
I don't fucking get it because first they say if the verdict is guilty for the crime he is criminally responsible, the verdict rendered with respect to the crime for which he is not criminally responsible must be set aside and deemed vacated. Deemed a nullity.
all right, so this is what happens. So if the verdict where he is responsible,
He did do it.
okay, he did do it, and
But
if,
he's how old?
all right, so this is if he's 13, 14. All right, I'm going to use a 13-year-old. It's the easiest to explain with a 13-year-old. So 13-year-old is charged with murder in the second degree. That's
Okay.
the only thing that they can charge him with, right? That that the jury can find him criminally responsible for.
Or if it was 14 or 15, murder too, and one of those other things.
Right, with the the machine guns and the
Okay, I
sex
gotcha.
and whatever. Okay.
Let's say he's 13 and he commits murder too, and that means that he is criminally responsible.
Well, let me finish. So
Okay.
he's charged with murder in the second degree. But because of that thing we read before, the court is also allowed to submit manslaughter in the first degree. But the defendant would not be criminally responsible for that. Okay, so they submit manslaughter. What's another lesser included? Criminally negligent homicide. They submit those things, right? The jury comes back not guilty on murders too, right?
Okay.
And
By reason of infancy?
no, they just say not guilty.
Okay.
That he didn't intentionally kill anyone. He was,
Okay.
it was an accident or something. All right. So they come back with not guilty on murder too, and they only come back guilty on criminally negligent homicide, right?
Okay.
In that case, the court vacates the verdict and replaces it by a juvenile delinquency fact determination. And that is when they remove the action to family court pursuant to 725. So that's the
Right.
only time they remove it pursuant to
Or
720.
722?
No.
725.
725 is after the conviction.
Oh, okay.
I think.
We don't have 725 on our test.
No, we don't. So that's why I have completely ignored that section. All right, so now the other one, this is the one with the verdict of guilty with respect to a crime he's criminally responsible for, or a defendant is waiting sentence on another conviction. So this is if they come back on murders in the second degree, but they also come back with the manslaughter and the criminally negligent homicide, which I think are inconsistent counts,
Right.
but whatever. It's for the purpose of this example. So the verdict of guilty on the murder two stands. But the verdict of guilty on the other two things that he's not criminally responsible for are set aside and shall be deemed a nullity.
So,
Because there's no point in sending him to family court when he's gonna get life in prison for the murder in the second degree.
okay, so if the verdict of guilty for a crime which the defendant is criminally responsible for, the verdict rendered with respect to the crime for which he's not criminally responsible for. Oh, so I think that's what confused me. They're talking about two separate crimes.
Yeah.
In my head, I was thinking it was one crime, and I'm like, wait, he is or he isn't? You know what I'm saying?
Yeah. So in the
So that's what
second
they're
one,
saying. So that's what they're saying. If they come up with a guilty for one crime, which he is criminally responsible for, or if he's awaiting sentence for another criminal action or under a sentence of another criminal action, then the verdict for the respect to the crime which he's not criminally responsible for should be set aside and shall be deemed a nullity. I think the word then should be put in there.
I agree, but it's
Because then it makes sense. Then the verdict.
yeah, I mean, I mess this one up all the time because I forget about the thing being set aside and deemed a nullity. But
Okay.
the other
So
one,
now-
hopefully if they ask us something on this, it's going to be the one about the vacated and JD
And that's
fact.
the next one. That's the next one.
That one's easier.
In any case where the verdict is not set aside, the court must order the verdict be deemed what?
Vacated and replaced by a juvenile delinquency fact determination. And then it gets
Correct.
removed. Then the court must direct it's removed to the family court.
JD 725.
And do you understand why that it's saying it's not set aside pursuant to subdivision 2?
No.
Okay, it's saying that because it's saying in the circumstance where he was only found guilty of stuff he's not criminally responsible for, and he's not awaiting or under sentence of imprisonment for another criminal conviction, we have to send this case to family court.
Oh, because that's it. That's all.
That's it. That's it. There's nothing more for the Superior Court to do.
Right. Okay. Got it. Set aside. I just spilled my water again, motherfucker.
All right, let me pause it.
All right. So let me just sum up those two things real fast again, and that's the end of this tape of this one. It says where the verdict of guilty is rendered by the defendant who is not criminally responsible by reason of infancy, the court shall proceed as follows. If the verdict of guilty for a crime which the defendant is criminally responsible for, or is awaiting trial for another conviction, sentence, or under a sentence of another criminal conviction, then the verdict with respect to the crime for which he is not criminally responsible for must be set aside and deemed a nullity.
Yep.
In any case where it's not set aside, the court must order the verdict be deemed vacated and replaced by a juvenile delinquency fact determination. Done.
All right. This one.
32010, except where the indictment charges the crime of murder 1. The defendant may at any time before trial waive a jury trial and consent to a trial without a jury. Got it?
Yeah.
2, such waiver of a jury trial must be...
Okay, this is signed by defendant in person in open court in presence of the judge and approval of the judge.
That's it.
And then the court has to approve the execution and submission of the waiver unless there's 2 reasons.
I don't have, but
all right, so
later in the test.
It's probably later on.
I just have 3 things. I just have the waiver, such waiver of a jury trial must be A, in writing, B, be signed by the defendant in person in open court in the presence of the court, and 3, have an approval of the court.
All right, so let me just tell you why they have to approve, when they have to approve it, unless. So the court must approve the waiver unless, 1, it is tendered as a stratagem to procure an otherwise impermissible procedural advantage, or 2, that defendant is not fully aware of the consequences of the choice he is making. And if the court disapproves the waiver, it has to state its reasons. But if it approves the waiver, it doesn't have to say anything. It just has to say approved.
Okay. True or false, a non-jury trial of an indictment must be conducted by one judge of the Superior Court where the indictment is pending.
True.
True or false, the court, in addition to determining all questions of law, are the exclusive trier of all issues of fact and must render a verdict.
True.
And why don't you just, the last thing on this test is the order of the non-jury trial. Do you know what? What do you want to read?
All right, let me try. Okay, so the court must allow the parties to deliver openings.
Right.
And then the people must offer evidence in support of the charge and call witnesses.
The people must deliver an opening address.
People must deliver opening address. People must offer evidence in support of the charge. Oh, no, I forgot. Hold on. The defendant must be also permitted to deliver an opening if he wants.
Must be permitted, but he may.
He may.
Right.
Okay. Then the DA has to put on a case.
Right.
Then the defendant may offer evidence in rebuttal.
Right.
Then DA may rebut that. Defendant may rebut again.
Right.
Then the court must allow defendant to sum up if he wants.
Right.
Then the court must allow the people to sum up if they want.
Right.
Then the court must, deliberate with itself and render a verdict.
Perfect. Do you want me to read it just so it's all...
Yes.
The order of a non-jury trial of an indictment, the court must permit the parties to deliver an opening address. The people must deliver their open address. The defendant may deliver his opening address.
Wait, I don't think the people must.
The people must?
I don't think so. I think it's the court must permit them.
Let's check it out. It's 320.10. Let me look.
Because I know I've worked with judges who are like, no, call your witness.
Oh, yeah, you're right. 320.10, let me see.
Which I guess they're not allowed to do, but I mean, I think that if the people had to open, they wouldn't do that.
All right, 320. Oh, I'm looking in fucking family. Do you have I have my criminal book right here. Oh my God, this book looks so different than the family book. right? When you've been in family for a while and then you open the criminal book.
Oh, I don't even have the family book. I'm using my phone.
Oh
I have a 2017 family book.
I can't believe you're studying with your phone.
Well,
All right,
only because I have a 2017 book.
All right, here it is. 320.10.
3/20/20.
320.20?
That's what you
Okay.
said.
The jury trial of an indictment must be conducted by one judge in the Superior Court. The court must permit the parties to delivering an opening address. The order of the evidence must or may be offered. I think you're right. It's may, because it only says the court must permit the parties to deliver an opening address, and then it says the order in which evidence must or may be offered by the respective parties is the same as 260.30, and then the court must permit the parties. So I think.
You know what? You know why I think that's wrong? And my dad said that in class, and I was like, dude, I think you're wrong. Because
it doesn't
say that. It doesn't say that.
It doesn't say must.
No.
It doesn't say must. They don't really, they don't even really address that.
No, it just says that they have to be allowed to if they want.
So I'm going to remove that must and put a may. Right?
Yeah.
I mean, I just thought it was must because the people have to explain what they're doing there.
No, they don't. The judge doesn't need the people to tell them what they're going to prove. The judge knows.
The judge knows. You're right. Okay, so let's change it to may. All right, so let's do that again. The court must permit the parties to deliver the opening address. The people may first deliver their opening address. The defendant may second deliver his opening address. The people must, however, offer the evidence. The defendant may offer evidence. The people may offer evidence in rebuttal. The defendant may offer evidence in rebuttal of the rebuttal. The court must permit the parties to deliver summations, starting with the defendant. If he may deliver his summations, and then the people may deliver their summations, and then the court must retire to deliberate. Done.
Yes.
3:30. Upon the verdict of complete acquittal, the court must immediately what the defendant if he is in custody.
Discharge and exonerate bail if there's bail posted.
Perfect. 3:30:20 procedures following the verdict of plea of not responsible by reason of mental
Oh
disease.
my God, I'm gonna fail this.
This is when we get into all those orders.
Oh,
right?
I never remember
No,
any of
you're
these.
good. You know every answer.
I did this last night and I got like 4 wrong.
You're not going to get any wrong today.
I hope not.
Okay. Well, this is definitions. This is blank means the State Commissioner of Mental Health or the State Commissioner of Mental Retardation and Developmental Disabilities.
Qualified psychiatrist?
Commissioner.
Fuck!
So
Fuck, what is it again?
Straight commissioner means the State Commissioner of Mental Health is the commissioner, and the State Commissioner of Mental Retardation and Developmental Disabilities is the commissioner.
Okay.